In this lesson, we're going to begin our discussion of criminal capacity. Specifically, we're going to focus on the competency of the criminal defendant to stand trial. Important to recognize from a big picture perspective that this issue, the competency of a criminal defendant to stand trial, is a completely distinct and separate issue from the not guilty by reason of insanity defense under the McNaughton test, the irresistible impulse test, the model penal code test, and the Durham or product test. Right, we're going to discuss the not guilty by reason of insanity affirmative defense under these different formulations in a lot of detail in our next lesson. The reason I bring it up in this lesson is because it's important to make the distinction when we're thinking about capacity of the criminal defendant between competency to stand trial and the not guilty by reason of insanity defense, both from a procedural and substantive perspective. Right, so first off, the major difference here is that the competency to stand trial issue is going to be determined by the judge, right? It's a question of law that will be determined before we even get to a trial. Right, the issue here is whether the defendant is even competent to stand trial. Can we even subject this defendant to a criminal trial? Right, and this is a question of law that's going to be decided by the judge before we can even have a criminal trial. The not guilty by reason of insanity defense, of course, is an affirmative defense that's asserted by the criminal defendant. Right, the competency to stand trial issue can be raised by either party. The defendant can raise this issue, the prosecution can raise this issue, the judge in certain cases could even raise this issue. Right, it's a question of law that's decided before the trial even begins. Right, not guilty by reason of insanity is an affirmative defense that's raised by the criminal defendant. And it's ultimately a question of fact that will be determined by the fact finder, who is usually the jury. Right, so again, very important that we don't commingle these concepts. They're very separate, distinct, both substantively and procedurally. Okay, but in this lesson, we can quickly get through competency to stand trial. In our next lesson, we'll really break down the different formulations of the insanity defense in a lot of detail. But we can start with competency of the criminal defendant to stand trial. So pursuant to the Due Process Clause of the United States Constitution, a criminal defendant must be competent to stand trial. An incompetent defendant is not going to be able to effectively communicate with his attorney, right, which is going to be problems with effective assistance of counsel. An incompetent defendant isn't going to be able to testify on his own behalf. An incompetent defendant is going to have issues, right, challenging his accusers or confronting his accusers. There's all kinds of issues from a due process perspective that we run into with having a incompetent criminal defendant stand trial. So we say pursuant to the Due Process Clause of the United States Constitution, a criminal defendant must be competent to stand trial. In making this determination, we say that a defendant is incompetent if during the criminal proceeding he lacks the capacity to consult with his attorney with a reasonable degree of rational understanding, or if he lacks a rational as well as factual understanding of the proceedings against him. Again, this is a question of law that's going to be determined by the judge before we can even get to a trial. Now, it's very important to recognize that judges are not psychiatrists, right? Making these determinations is not something a judge is going to be able to do on his own or on her own, right? They're going to need the help of a psychiatrist. So usually what's going to happen here is we're going to have a psychiatric court-ordered evaluation, right? To really help the judge make this determination. So the defendant is going to be subject to a psychiatric evaluation. We're going to get findings from that psychiatrist. The findings are going to be distributed to the prosecution and to the defense. If the findings are undisputed, right, the judge is usually going to make a determination based on those findings. If the findings are disputed by either side, then we'll get a pretrial hearing, and at the pretrial hearing, both sides can present evidence as to the competency of the defendant to stand trial. But either way, right, the judge is ultimately going to determine whether the defendant is competent to stand trial or not. And again, it's important to recognize here that judges are not psychiatrists. They're not experts in this field. They're going to rely very heavily on the psychiatric evaluation in making these determinations. But things that the judge is going to be looking for, and what you could look for in a criminal law analysis, would be when we're thinking about whether the defendant lacks the capacity to consult with his attorney with a reasonable degree of rational understanding. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.